for however many years she did, only to be lectured by you, and that is how I feel. So why don't you just stop lecturing the rest of us? Just because you think you are the smartest person in the world doesn't mean the rest of us agree to that, okay? Thanks.
At a Senate Judiciary Committee hearing on voting rights and gerrymandering, Senator Mazie Hirono and Senator Ted Cruz delivered sharply different views on racial discrimination, election laws, and the legacy of the Voting Rights Act. What began as a debate over voting rights quickly turned personal, ending with a tense exchange between the two senators. Here's what happened.
There's absolutely no question that racial discrimination existed in our country, and in many places, people would argue that it still does. And so we had all kinds of ways to keep black people from voting. We had poll taxes, we had literacy tests, we had, I think some places even required them to count how many jelly beans were in a jar. All kinds of ways to keep black people from voting. This happened. I don't think anybody can deny that that was going on. And as far as I'm concerned, there is a pattern now of voter suppression going on in our country right now. And the Calais decision just plays into that by pretty much gutting the Voting Rights Act, which, by the way, was reaffirmed many times in a bipartisan way in acknowledging that this kind of racial discrimination occurred, and that as a democratic country where everybody has an equal vote, that's not tolerable. But suddenly it's A-OK just because the Supreme Court says so. No, it's not the entire Supreme Court. It's a 63 majority, which I consider to be basically an out-of-control Supreme Court majority where there is a pattern of this kind of decisions out of this court. So just because this court says so doesn't mean I agree with them. So meanwhile, there is voter suppression going on. You have an attorney general who sued at least 29 states to get these states to turn over their voter rolls. Why? What does the Department of Justice, what does the executive branch want to do with all this voter information? Up to no good, I would say. There's this huge push to pass the SAVE Act. It's more Save Trump Act. And what does that act do? It would require millions and millions, all of us who are registered to vote, suddenly we will have to show proof of citizenship, either through a birth certificate or a passport. Millions of people don't have either. Married people who take their partner's name will not have a name that matches their birth certificate. So what are they going to do? There are going to be millions of people who are not even going to register to vote. And you think Trump doesn't know that? Of course he does. That's why he wants the SAVE Act to be enacted. That's why the Republicans would like to see the SAVE Act enacted, because they know that millions of people will be literally disenfranchised by not even being able to allow to vote. And then with this regime, once you do vote, they will challenge your vote as they did in the last elections. So voter suppression is going on. It's very reminiscent to the kind of stuff that was going on that the Voting Rights Act was intended to address, to fix. And now you have a Supreme Court that says, oh, never mind all of that, never mind all of that history. And over 3 cases, they succeeded in gutting the Voting Rights Act. And don't tell me that the provisions of the Voting Rights Act still exist in a way that is pretty much unenforceable, because the racial gerrymandering is going to be okay unless the legislative body that does the gerrymandering says, oh, by the way, we intend to racially discriminate. Are you crazy? You think that state legislators are going to be that overt about it? Of course not. So you have a Voting Rights Act that you claim is still intact. Please, give me a break. I have a question for Mr. Cox. Last weekend, thousands of people, and apparently you were among them, gathered to protest the Supreme Court's gutting of the Voting Rights Act. The central locations for these protests were Montgomery and Selma, Alabama, and both significant sites in American civil rights history. Mr. Cox, can you put this current moment into historical context for us? For instance, why is this moment reminiscent of when the last Congressman, John Lewis, who many of us consider a friend and hero, led over 600 peaceful protesters across the Edmund Pettus Bridge in Selma, Alabama?
Thank you, Senator Hirono, for that question. I think it's reminiscent and reflects the fact that the Voting Rights Act was not given to us. It was not bestowed on us. It really came from the people. And the joke I'm sort of making is that Justice O'Connor used to say were more lawyers in D.C. than people. I think we sometimes feel that way in D.C. We're on the Hill. Lawyers are at the center of the universe, and that's just not true. If we're going to climb out of this destruction of the Voting Rights Act, the penultimate destruction of our democracy, it's going to require the people. And quite frankly, we're being gaslit. We have a Supreme Court, we have allies of the Supreme Court and allies of the Calais case saying discrimination is over. Obviously not true. We have folks on the ground showing and discussing with us that law enforcement are at the polling places. We have folks not only confused, but being discriminated against right now. And I have to say that to ignore the fact that the people are demanding that Congress respond, that Congress restore the effects test that has been gutted and taken out by Calais would be a mistake. Because folks understand and know what is happening outside in the real world. And they know, particularly black voters know, that they aren't going to return to the 1800s and what we all experienced, or our ancestors experienced, that led us to the Voting Rights Act in the first place.
And in fact, I want to go back to her comments. She began by saying we have a long history of racial discrimination in this country. That's undoubtedly correct. And then she said, quote, we had poll taxes, we had literacy tests, we even had tests of how many jelly beans are in a jar. Mr. Chamberlain, when Senator Hirono says we had poll taxes, I want to ask you who we is, and in particular, what party was it that implemented poll taxes in the South?
I mean, I don't want to necessarily speak in every single case, but I'm pretty confident it was mostly the Democrats.
And what party was it that put literacy tests in place in the South?
Same answer, mostly the Democrats.
And what party was it that had tests like how many jelly beans are in a bottle?
The Democrats.
Tell me, what party were the founders of the Ku Klux Klan from?
I'm pretty sure that was the Democrats.
Indeed. In fact, Nathan Bedford Forrest, the founder of the Klan, was a delegate to the 1860 Democrat National Convention. What party wrote the Jim Crow laws in the South?
The Democrats.
And so on this side of the aisle were members of the Republican Party. Who was the first Republican president?
Abraham Lincoln.
The Republican Party was literally founded to oppose slavery. We came into existence because slavery was a grotesque evil, and it was President Lincoln, the first Republican president, who signed the Emancipation Proclamation, who won the Civil War, and that resulted in the freeing of the slaves and the passage of the 13th, 14th, and 15th Amendments. By the way, fast forward to the Civil Rights era. Bull Connor, one of the most noxiously racist politicians, what party was he from?
He was a Democrat.
The Democrats, for the entire history of their party, have been a party based on racial discrimination. They affirmatively embrace it. They support it. Let me ask you, Mr. Grime, is discriminating based on race consistent with the United States Constitution?
No.
What does the 14th Amendment say about discrimination based on race?
It's prohibited.
What does the 15th Amendment say about discriminating based on race, and in particular drawing congressional lines and explicitly discriminating based on race?
It's prohibited.
Now, the Democrats are fond of telling this story that is, and I wish I could find a kinder way to say it, a flat-out lie. That without discriminating based on race, that no African Americans will be elected and no Hispanics will be elected. Indeed, there was one fellow online who was a vocal left-wing spokesperson who tweeted out, if I'm advising anybody to run for president, they sure as hell better have a solution to how you make sure that it's not another 100 years before another black person can represent South Carolina. So that's a typical Democrat statement, that we cannot elect a black person in South Carolina without discriminating based on race. I want to ask you, Mr. Chamberlain, Who is the junior senator from South Carolina right now?
That would be Tim Scott.
And, all right, I'll tell you what I said online. I said, hey, Grok, who is Tim Scott? And why do Democrats think he isn't black? And by the way, was Tim Scott elected because of a gerrymandered district drawn only to elect an African American?
No, he won statewide.
He won statewide. By the way, the Democrat position is you can only elect African Americans with a gerrymandered district. I will point out Burgess Owens, an African American, is elected in a majority white district in the state of Utah. He's a Republican. Byron Donalds, another African American, is elected in a majority white district in Florida. He is a Republican. John James, another African American, is elected in a majority white district in Michigan. He is a Republican. And my own congressman, Wesley Hunt, who represents me in the House of Representatives, he is elected in a majority white district. He is a Republican. And yet, in the Democrats' world, you're not black if you're not a liberal Democrat. There is an arrogance to African American voters. By the way, they also have that same arrogance to Hispanic voters. They say you're not Hispanic if you're not a liberal Democrat. Well, I'll tell you, I am proud to be the first Hispanic ever elected to represent the state of Texas in the United States Senate. And Mr. Chamberlain, in my election in Texas, was I elected in a gerrymandered district that could only elect an Hispanic?
No, you were elected statewide.
Discrimination based on race is wrong. Final question. The Democrats are now clutching their pearls that seats drawn to elect liberal Democrats in the South are going to go away. You may get black Republicans instead. Indeed, in Tennessee, they're freaking out that a liberal white guy who's a Democrat is likely going to lose his seat to an African-American woman who's a Republican, and they say that's horrible racial oppression. My final question is this. If you look nationwide, which party has egregiously abused gerrymandering for decades? Both parties are guilty of it, but who has been the worst offender? And in particular, take New England. Take Massachusetts, take Connecticut, take Rhode Island, take Maine, take Vermont, take New Hampshire. How many Republicans are elected from all of New England in the House of Representatives?
I think the answer to that is zero.
Zero. They've drawn every district in a naked gerrymander, and yet they're very upset that their illegal pursuit of power has now been stopped by the Supreme Court that is enforcing the Constitution and prohibiting the racial gerrymandering and discrimination their party is built on.
I feel personally aggrieved to sit here and to be lectured by my colleague from Texas. And this reminds me of the time when he was first elected to the Senate, and the Judiciary Committee had a hearing on gun safety, and he felt a need to lecture Dianne Feinstein, who was a leader on gun safety legislation, and he took that opportunity to lecture Dianne Feinstein about gun safety and her leadership on the issue. And she said to him something along the lines of, I did not sit here on this committee for however many years she did, only to be lectured by you, and that is how I feel. So why don't you just stop lecturing the rest of us? Just because you think you are the smartest person in the world doesn't mean the rest of us agree to that, okay? Thank you.
Senator Hirono,
Senator,
I knew
Senator Cruz.
Dianne Feinstein. I served with Dianne Feinstein, and you're not Dianne Feinstein.
All right, Senator.
This hearing was ostensibly about voting rights and racial gerrymandering, but the discussion quickly evolved into a much broader debate about how America understands equality, representation, and constitutional law. What made the exchange particularly noteworthy was not simply the disagreement itself, but the fact that both sides framed their arguments as defenses of civil rights and democratic participation while reaching almost completely opposite conclusions. Senator Mazie Hirono began by placing the discussion within the historical context of racial discrimination in voting. Her remarks focused heavily on the barriers that minority voters face throughout American history, including poll taxes, literacy tests, and other mechanisms that were designed to suppress participation. By invoking these examples, Hirono sought to remind listeners that voting rights protections did not emerge in a vacuum. They were created in response to documented abuses that prevented many citizens from exercising their right to vote. A central feature of her argument was the idea that history continues to shape the present. Rather than viewing discrimination as a problem that has largely been solved, Hirono suggested that many modern debates over voting laws should be understood as part of a continuing struggle over access to the ballot box. In her view, contemporary disputes about voter registration requirements, election procedures, and redistricting cannot be separated from the broader historical experience of minority communities. Hirono also criticized recent Supreme Court decisions involving the Voting Rights Act. Her argument reflected a concern shared by many voting rights advocates who believe that legal protections once used to challenge discriminatory practices have been significantly weakened. According to this perspective, the removal or limitation of these protections makes it more difficult to identify and remedy policies that disproportionately affect minority voters. Another significant aspect of Hirono's remarks involved her criticism of proposals that would require voters to provide additional proof of citizenship. Supporters of such measures generally argue that they are necessary to strengthen confidence in elections and prevent ineligible voting. Critics, however, contend that these requirements can create practical obstacles for eligible citizens who may not have immediate access to the necessary documentation. Hirono emphasized this latter concern, arguing that even well-intentioned regulations can have unintended consequences if they make participation more difficult. The witness responding to Hirono reinforced many of these themes by discussing the historical significance of voting rights activism. His testimony highlighted the role of grassroots movements and public pressure in securing legal protections during the civil rights era. The broader implication of his remarks was that legal rights often depend upon sustained public engagement and vigilance. In that sense, he framed the debate not merely as a legal disagreement, but as a question about civic responsibility and democratic participation. What is particularly interesting about Hirono's position is that it reflects a philosophy that places substantial emphasis on outcomes and lived experiences. Rather than focusing exclusively on whether a law is formally neutral, this perspective asks how policies operate in practice. If a policy creates barriers that disproportionately affect certain communities, advocates of this view argue that lawmakers and courts should take those effects seriously when evaluating the law's fairness. Senator Ted Cruz approached the discussion from a markedly different perspective. While Hirono focused on historical discrimination and contemporary voting rights concerns, Cruz concentrated on constitutional principles and the dangers of government decision-making based on race. His questioning reflected a belief that racial classifications, even when used for purposes that supporters consider beneficial, can conflict with a constitutional promise of equal treatment under the law. One of Cruz's primary arguments involved the history of political parties and civil rights legislation. By referencing historical examples of discriminatory practices associated with Democratic politicians in earlier eras, Cruz attempted to challenge what he viewed as an oversimplified narrative about race and political identity. His goal appeared to be demonstrating that political parties and ideologies evolve over time and that contemporary debates should not be reduced to simplistic historical assumptions. Cruz also emphasized the constitutional amendments adopted after the Civil War, particularly the 14th and 15th Amendments. His argument centered on the principle that government should not discriminate based on race. From this perspective, drawing electoral districts primarily on the basis of racial considerations can create constitutional concerns, even when the intention is to enhance minority representation. A major component of Cruz's presentation involved examples of minority politicians who achieved electoral success outside majority-minority districts. By highlighting these cases, he sought to demonstrate that minority candidates can win support from diverse constituencies without the need for race-based district boundaries. His argument implied that assumptions about voting behavior can sometimes underestimate voters' willingness to support candidates from different racial or ethnic backgrounds. This point touches on one of the most significant philosophical disagreements in modern election law. Supporters of race-conscious districting often argue that it helps ensure minority communities have meaningful opportunities to elect representatives of their choice. Opponents counter that emphasizing race in the districting process risks reinforcing racial divisions and treating citizens differently based on racial categories. Both sides claim to support equal representation, but they disagree fundamentally about how that objective should be achieved. The hearing therefore highlighted a tension that has existed for decades within American constitutional law. On one hand, there is a commitment to eliminating discrimination and ensuring fair representation for historically marginalized groups. On the other hand, there is a commitment to treating individuals as equals without regard to race. The challenge arises when policymakers and courts must determine how these principles should interact in specific circumstances. What made the exchange especially compelling was that both senators framed their positions as defenses of democratic values. Hirono argued that robust protections are necessary to prevent discrimination and preserve access to voting. Cruz argued that constitutional equality requires limiting the use of racial classifications in government decision-making. These positions are not merely policy disagreements. They reflect different understandings of what equality means in practice. As the hearing progressed, the tone became increasingly confrontational. While much of the discussion focused on substantive policy issues, underlying political tensions were clearly present. This is not unusual in congressional hearings, particularly when the subject matter touches on highly contested questions involving race, elections, and constitutional rights. Such issues often carry significant political implications, making consensus difficult to achieve. The most memorable moment occurred near the conclusion of the exchange, when Senator Hirono expressed frustration with Cruz's presentation style. Her comments shifted the discussion away from legal and historical arguments and toward the dynamics of the committee itself. By referencing an earlier exchange involving former Senator Dianne Feinstein, Hirono suggested that Cruz had a tendency to lecture colleagues rather than engage them as equals. This moment was significant because it revealed how personal dynamics can influence public policy debates. Congressional hearings are often portrayed as purely intellectual exercises, but they are also political and interpersonal events. Legislators bring with them years of experience, institutional relationships, and personal perceptions that inevitably shape their interactions. Cruz responded with a brief remark of his own, further highlighting the tension between the two senators. Although the exchange was short, it became one of the most widely discussed portions of the hearing because it transformed an abstract policy debate into a visible interpersonal conflict. Such moments often attract attention because they provide viewers with a glimpse into the human dimension of political institutions. From a broader perspective, the hearing illustrates the enduring complexity of voting rights debates in the United States. Questions about district boundaries, electoral representation, and constitutional equality rarely produce simple answers. Reasonable people can agree on the importance of democratic participation while disagreeing sharply about the best methods for achieving it. The discussion also demonstrates how historical narratives continue to shape contemporary politics. Both senators relied heavily on historical references, but they used those references to support different conclusions. Hirono emphasized the legacy of discrimination and the need for continued vigilance. Cruz emphasized constitutional principles and cautioned against policies that classify citizens by race. The fact that both arguments drew upon history underscores how interpretations of the past often influence debates about the future. Ultimately, this hearing was about far more than one court decision or one legislative proposal. It reflected competing visions of representation, equality, and democratic governance. The disagreement between Hirono and Cruz was not merely a clash of personalities. It was a reflection of deeper ideological divisions that continue to shape American politics. For viewers seeking to understand the significance of the exchange, the key takeaway is that both sides were arguing over the meaning of equal representation in a diverse democracy. One side emphasized protecting communities that have historically faced discrimination. The other emphasized ensuring that government decisions are made without regard to race. These perspectives are not easily reconciled, which is why debates over voting rights remain among the most contentious issues in public life. As future court cases, legislative proposals, and redistricting battles emerge, many of the same questions raised during this hearing are likely to reappear. How should representation be measured? What role should race play in public policy? How should courts balance competing constitutional values? These questions remain unresolved, ensuring that the debate witnessed in this hearing will continue long after the committee session itself has ended.